continuing with the Starbucks judgment, if I could ask you to continue at paragraph 90 of that judgment. So this is where the judge sets out the law on distinctiveness and descriptiveness, which is cited in the judgment under appeal. None of that's controversial, so moving forward to paragraph 96 on page 286, and this is a paragraph that the court was taken to earlier, where Mr. Justice Arnold raises the point as to whether a sign containing visual content is sufficient to prevent it from consisting exclusively of subject matter within the scope of Article 7C, so the impact of that. And then makes the point that the public policy considerations under Article 7.1c apply. If I could ask you to read from accordingly. Accordingly, he submitted that a sign remains objectionable under Article 7.1c if it is basically descriptive by reason of the visual and hence oral and conceptual dominance of the wording it contains, even if it contains some other visual. He then goes on to give an example of that approach in Hormel Foods, where the spam buster sign shown there was held to be objectionable under the equivalent of section 3.1c in respect of computer programming. Then at paragraph 97, Mr. Justice Arnold makes the point that an alternative approach is, instead of saying that the sign is descriptive, if it's considered to be nominally stylized, you can say that it lacks distinctiveness. Some examples are given, but again, every case turns on its own facts. Then a few paragraphs that the court was not taken to and I think are important. Paragraph 99 under the heading assessment, Mr. Justice Arnold makes the point that it was common ground that the dominant element of the CTM was the word now. And in fact, he goes on to say that in that case, the claimant, whose mark was being challenged, went further and made the point in its skeleton argument that the figurative element adds nothing to the distinctiveness of the mark. So the claimant in that case had even abandoned any reliance on the stylization and effectively just said that it is just the word now, as Mr. Justice Arnold recorded. And then paragraphs 116 and 117, which again the court was taking to. And so taking all of the evidence into account, I conclude that the CTM is precluded from registration on the basis that it's descriptive. The figurative elements of the CTM do not affect the conclusion. In the alternative, if the inclusion of the elements mean that it does not consist exclusively of the unregisterable word now, I consider that it's devoid of distinctive character. And then he makes the point at paragraph 117 that I would comment that it appears to me that the claimant only succeeded in obtaining registration because it included the figurative elements, yet the claimant is seeking to enforce the CTM against signs which do not include figurative elements. That was an entirely foreseeable consequence of permitting registration, and then he makes the point about trademark registries should be astute to the consequence of registering descriptive marks under the cover of a figurative fig leaf. Now that's hardly a surprising conclusion on the facts of that case, including in circumstances where the claimant itself contended that the stylization added nothing to the CTM, which was for the word mark now alone. So that's a relevant background to the figurative fig leaf comment, which needs to be understood in context, and as I'll come to, there are no parallels with the judge's analysis in this case. The next case that the judgment under appeal cites on this point is a decision of Mr. Geoffrey Hobbs in the Flying Scotsman. And if I could take the court to that, it's in the Joint Authorities bundle at tab 10. So picking that up, please, at page 245.
Oh, Mr. Solmy, I'm so sorry to interrupt you, but I meant to observe that just in the timetable, looked like we were running about 25 minutes ahead. And I just wanted to note that because I wasn't expecting you guys to use that time any more than your opponents did.
I'm certainly not going to run any longer. So
very good. Sorry, I interrupted you. Beg your pardon. Where are we going?
The Flying Scotsman, so the Joint Authorities bundle, tab 10, page 245. Thank you. And it's the mark shown there under paragraph 1, which is the Flying Scotsman's mark, which was registered for a wide range of goods and services. Now, the registrar objected to that mark on the basis that it was descriptive and lacked distinctiveness for example, electronic publications in Class 9, printed matter in Class 16, and toys, games, and playthings in Class 28. In essence, the hearing officer had held that the trademark would be perceived as the subject matter of those goods. So, for example, the subject matter of printed matter in Class 16, so it was held to be descriptive. Then if I could ask the court to pick up the judgment at the top of page 247, the paragraph numbered 22, which is a citation of the registrar's reasoning. And here it says, the only remaining question is whether this combination of words and device creates a whole greater than the sum of its parts. And
Which
will
one? You said
overcome.
22.
It's the top of page 247. It's citing paragraph 22 from
I
the
see,
original.
Paragraph 5 of the decision.
Paragraph 5 of the decision citing paragraph 22 of the
Right,
original.
I went to 22 the decision. My fault. 5. Yeah, got you.
So the only remaining question is whether this combination of words and device creates a whole greater than the sum of its parts, and that it will overcome the descriptive nature of the word combination and the device for steam locomotive. I do not see how they can. The device supports the meaning of the words, but adds nothing to them. There is a degree of stylization to the device, but it's clearly a steam locomotive, and in conjunction with the words, it will be perceived as a slightly stylized representation of the steam locomotive named Flying Scotsman. And then at paragraph 24, consequently, I've concluded that in respect of the goods identified at paragraph 10, the mark consists exclusively of a sign which may serve in trade to designate the kind of, and is therefore excluded from registration on the grounds that it's descriptive. On appeal to the appointed person, the applicant contended that the hearing officer had wrongly characterised the sign in issue as a mark in which the device supports the meaning of the words but adds nothing to them, and that the hearing officer had therefore not taken account of the overall capacity of the sign to serve as an indication of trade origin when considering descriptiveness and distinctiveness. And against that background, the appointed person first considered the distinctiveness of the mark, picking up the judgment at page 255, paragraph 24. And the appointed person says the issue for determination against that background is whether the sign nevertheless conveys a message about the content or character of the goods by means of a graphic representation, which would, from the perspective of the relevant average consumer, serve to individualize them. That primarily depends upon the effect that the non-verbal content would be likely to have upon the perceptions of individuals exposed to the use of the sign as a whole in relation to such goods. And then in paragraph 25, there is enough artistry and creative expression in the non-verbal element, the non-verbal content, to satisfy me that the sign as a whole will be seen as alluding emblematically to the content and character of the goods concerned. I'm reinforcing that view by the examples of use the applicant has provided. It remains to be determined whether, as a result of the artistry and creative expression, the sign possesses a distinctive character in the relevant sense of the word, i.e. being able to indicate trade origin. Then the appointed person in paragraphs 26 and 27 summarises the case for and against registration, concluding at paragraph 28, both approaches involve assessment of the sign without dismemberment or excision. By contrast, the hearing officer's finding that the sign was excluded from registration by section 3.1c was made upon the basis that the device supports the meaning of the words, but adds nothing to them. In the result, he tested the application for registrability under that section as if it was an application for registration of the words without more. I regard that approach to assessment of the sign as untenable. It gave nil or negligible weight to the presence of non-verbal content, which simply could not be treated as insignificant in the context of the sign as a whole. So this is where we see the language insignificant in the context of the sign as a whole. But the important point is that the appointed person allowed the appeal on the basis that the mark was distinctive and the content was also sufficient to prevent it from consisting exclusively of subject matter within the scope of section 3.1c. The key point of principle to have in mind why did the appointed person overturn the decision?
No, why does it make sense to say that the I mean, the picture is a picture of a steam train. The steam train is obviously the Flying Scotsman. The point was that the Flying Scotsman, whether you write the words Flying Scotsman or draw a picture of a Flying Scotsman, designated the content of a book, say. So why does the fact that there's a picture of a Flying Scotsman mean it doesn't designate the content of a book?
So the point of principle from that is that you need to look at you can't dismember or excise a mark into its different elements. So obviously the Flying Scotsman denotes Flying Scotsman. The train perceived together with the Flying Scotsman words denotes a Flying Scotsman. But when you look at the mark as a whole, it's capable of distinguishing a particular undertaking from others. And in the context of descriptiveness, it's not exclusively descriptive because of the stylized element. So you get home on distinctiveness and non-descriptiveness.
Okay, well, I can see the legal principle might be right, but I don't quite understand how it makes any sense on the facts of that case, but maybe it doesn't matter.
I think for my purposes, it doesn't matter. The legal principle, the important point is that you can't excise or dismember the word elements from the stylized elements. You can't say the word element is descriptive, the stylized element effectively corresponds to the word meaning, so together it's descriptive. You need to look at the mark as a whole. Now, if I can turn to the judge's assessment of the descriptiveness of the marks in this case. So if you could pick up the judgment in the core bundle, tab 1, page 27.
And sorry, just for my benefit, what was held to be registrable was the combination that you showed us of the picture of the locomotive with the words underneath in that stylised way.
It's the combination. It was the entire sign.
So even though either piece of it by itself would be descriptive, you're drawing a comparison with shorts and the placing here. The particular combination and presumably the placement, the way they were arranged and so on, was sufficient.
It was precisely that
But the
combination.
key point seems to, the key underlying point is this a sign that can distinguish trade origin? It's that. That's what we're trying to grapple with, isn't it? That's the key.
So for the purposes of distinctiveness, the key point is whether it can denote trade origin. That's what a distinctive mark means. For the purposes of descriptiveness, it's whether it describes a characteristic of the goods or services. The legal tests are slightly different for both.
Well, yes, maybe I've been slightly, I think the passage you've just taken is to maybe picks up both. I'm looking at 25.
I mean, as I understand the legal principle, and the only legal principle actually, is that you can't look only at the word, and you in a case in which you have a word and something figurative, you can't look only at the word, and you can't look only at what's figurative. You do have to take them in combination. And ultimately the question is whether the combined thing satisfies the law or not. That is actually the only legal principle.
I think that's exactly right. I think that's the only legal
principle. And just to develop that one stage further, what is true, I think, is that of course you look at the relationship, if there is one, between the figurative content of the word, and it is possible, and the facts of Flying Scotsman illustrate it, even if the conclusion doesn't illustrate it quite the same way, that you can have a case in which the figurative content has a meaning which relates to the word, and that is all. And when you say it out loud, it's obvious that you should take into account any relationship conceptually between the figurative content and the word, and that might work in the trademark's favour, or it actually might work against the trademark. But you certainly have to do that.
I think that's right. You can't consider them in isolation. You need to consider them together, and then consider whether that sign is distinctive or is non-descriptive. So on the court's, on the judge's assessment of descriptiveness of the 2018 marks in this case, if I could ask the court to turn to the judgment under appeal. So this is core bundle tab 1, page 27. And here, paragraph 94. under the heading Section 3.1c Assessment. So the court's been taken to this already. I shall start by considering the 656 and 664 marks, stylized marks for shorts. The judge makes a point that they consist of the word shorts in an ordinary sans serif capitalized font, either black on a white background or white on a black background, and then the red triangle in the O. He makes the point that as of 20th February 2018, when those marks were filed, one meaning of shorts was short form audiovisual content. So that means that it's a description of a characteristic of the goods, at least in respect of sound, video and data recordings, cinematographic films, films for television and recorded television programs. He then goes on to make the point at paragraph 95. I now need to consider whether the presentation of the word shorts means that those marks do not consist exclusively of signs or indications, which may serve to designate characteristics, applying the approach I've explained above. And that approach is the one that he set out in Starbucks and Flying Scotsman. In my judgment, the font and the contrast between the lettering and the background are insignificant in the context of the mark as a whole.
And that's deciding something is insignificant in the same way as was decided in Flying Scotsman.
This is before he undertakes a complete analysis. So he's just looking at one element of the mark.
But it's not quite one element, though, is it? Because that was really what I was getting at. He's actually taking part of the figurative element of the mark, which is the font and the contrast, and looking at that as side by side with the words as a whole, and saying that that font and contrasting in the lettering is insignificant.
That's correct. And then he considers the place symbol within the O separately. So that leaves the red triangle in the O. In my judgment, the triangle would be recognized by the average consumer as a place symbol, designating a characteristic of the goods, namely that they can be played. And this is the important point. However, I need to consider the effect of the combination of the words shorts and the place symbol, rendered in red and located within the O. In my judgment, the way in which the two elements are combined is such that the mark does not consist exclusively of indications, which falls within section 3.1c. And then he goes on to say the combination creates an overall impression, which goes beyond a mere juxtaposition of two descriptive indications. He then goes on to say that whilst that's sufficient to dispose of descriptiveness, he considers descriptiveness on the individual goods and services on the contrary assumption, just in case he's wrong about the stylization point, which point Mr. Malinich addressed the court on, and which does not form part of Google's cross-appeal. Now, the judge's reasoning on the stylization point in my submission is unimpeachable.
So what do you mean? Forgive me. What stylization point do you mean?
The figurative fig leaf point. So he says because the marks have some stylized elements, they don't consist exclusively, and therefore they don't fall within section 3.1c. But in case he's wrong about that, we could imagine that it was just a word shorts alone. I'm going to consider whether that's descriptive for the goods and services that he goes on to consider. So in my submission, the judge's reasoning on the stylization point is unimpeachable for the following reasons. The first is that the respondent expressly does not take issue with the judge's summary of the law on this point, and it's clearly and correctly set out in paragraphs 87 to 90 of the judgment. The complaint with the judgment is that the judge allegedly failed to consider the question of whether the place symbol was a figurative fig leaf when he analysed the 2018 marks, and it's correct that he does not refer to that language at paragraph 96 or the analogous Flying Scotsman language. But obviously there was no requirement for him to recite that particular language, and it's plain that he had the correct test in mind and applied it correctly. We can see that from the following. The first is that I took the court at some length to the Starbucks judgment for the context behind the figurative fig leaf comment, which comment was made in factual circumstances where now was initially used without stylization, and a brand consultancy report expressly noted that a brand with such a definite and descriptive name is demanding, where the claimant then added minimal stylization to the letter O, but acknowledged in its trial skeleton that the stylization added nothing distinctive to the mark, which was for the word now alone, and where the mark appears only to have been registered because it included figurative elements. There are no parallels with the 2018 marks in this case. In this case, the judge himself noted the interplay between the word shorts and the place symbol, rendered in red and located within the O, and the impact on the overall impression of the marks. The appellant did not file the 2018 marks relying on the stylization alone to get the marks registered. It's apposite to note that the 383 mark is for Shorts TV without any stylization, and that mark was applied for and registered. And at no stage did the appellant throw the figurative elements under the bus by contending that they added nothing to the distinctiveness of the 2018 marks on the basis that those marks were for Shorts TV alone. So the judge was perfectly entitled and certainly within his judicial remit to conclude that the stylization rendered the 2018 marks registrable. Another important point to pick up on is that at paragraphs 95 and 96 of the judgment under appeal, the judge clearly had in mind that it was illegitimate to dismember or excise the 2018 marks into the figurative elements and the stylized elements, and they needed to be considered as a whole. He expressly refers to, in the context of the mark as a whole, and the overall impression in the marks, which is exactly the approach contended for by the Flying Scotsman. So there again, the judge had in mind and applied the Flying Scotsman test, and there's no basis to criticise the judge's reasoning on that front either. The third point that the respondent raises, or certainly was raised in the skeleton, I'm not sure if it's pursued orally quite like this, which is that instead of correctly applying the Starbucks or the Flying Scotsman's test, he's alleged to have misapplied a test from post-cantur relating to the descriptiveness of compound word marks. Now, I've made submissions as to why the judge had in mind and correctly applied the test relating to these stylized elements, but I think I need to say something in response to Google's argument. And if I could take the court back to the Joint Authorities bundle, tab 1. So this is post-cantur, and it's page 33 of that judgment. Paragraph 87, this is where the CJU reframed the fifth referred question. So the mark in that case was post-cantur, which is the Dutch word for post office for various goods and services. And post-cantur considered a number of things. One of the things that it considered was the registrability of post-cantur for various goods and services. The fifth referred question, the CJU said, in order to give a useful answer to the National Court, the fifth question must be construed as asking in essence whether Article 3.1c of the directive is to be interpreted as meaning that a mark consisting of a word composed of elements, each of which is descriptive of characteristics of the goods or services, in respect of which registration is sought, may be regarded as not itself descriptive, and if so, in what circumstances. So in other words, the CJU was addressing if a mark has multiple descriptive elements, in what circumstances it can be said not to be descriptive. The CJU went on to answer that at paragraph 104. Essentially saying that there needs to be a perceptible difference between the word and the mere sum of its parts, which assumes that because of the unusual nature of the combination, the word creates an impression which is sufficiently far removed from that produced by the individual elements, with the result that the word is more than the sum of its parts. And if I can return again to paragraph 96 in the judgment. So this is page 28 of the judgment. Google contends that in saying in the final sentence of paragraph 96, the combination creates an overall impression which goes beyond a mere juxtaposition of two descriptive indications. The judge had in mind the post-cantur test, but it was inapposite to apply it to a word and figurative mark, or a mark that has both word and pictorial elements, and that the judge failed to do it correctly in any event, because he never undertook expressly a visual, oral and conceptual comparison. In my submission, there's nothing to that point. The point that the judge was making at paragraph 96 is simply that the combination, including the stylization of the 2018 marks, creates an overall impression which goes beyond a mere juxtaposition of the word elements. So he's using the correct overall impression test, and he did not misapply anything. The fourth and final point that Google criticizes the judge for is the alleged inconsistency between the judge's approach to the plus symbol when considering revocation and considering the place symbol in the context of validity. And the essence of the complaint is that he's alleged to have exaggerated the importance of the place symbol, rendering the marks valid, whilst minimizing the plus symbol, rendering the plus form, Shorts TV plus, permissible variant use. If I could ask the court to turn to page 43 of the judgment, so paragraph 154. This is where the judge addressed whether Shorts TV plus counted as genuine use of Shorts TV. In paragraph 154, he says the dispute was whether the use of Shorts TV plus counted as use in respect of the 615 and 649 marks. Google contended that the addition of the plus altered the distinctive character because it was a prominent visual element, had conceptual significance in suggesting that something more is offered and adds an additional syllable orally. I do not agree that the addition of the plus alters a distinctive character, while I agree that it adds a visual element and an additional syllable orally and has some conceptual significance in suggesting something more. I do not agree that it adds anything significantly distinctive to the 615, 649 marks. Insofar as those marks have distinctive character, that distinctive character is retained rather than altered. And it is, with respect, hard to understand what this finding has to do with the judge's assessment of the stylization in the 2018 marks. First, the factual appraisals are completely different. One was relating to a plus, the other was relating to a place symbol. So the judge was entitled to reach a different factual evaluation on the basis of two completely different symbols. The second is that the issues are dealt with completely differently under two different statutory provisions. Section 46(2) for the case of revocation and Section 3(1) for the case of descriptiveness and lack of distinctiveness. My learned friend made a submission that the legal tests could be elided. In my submission, that's very wrong. The legal tests are entirely distinct when one considers revocation versus when one considers descriptiveness, including the importance of a stylized element in the context of descriptiveness. I don't think I need to say anything more about this at this stage, and will address revocation, which is the respondent's sixth ground for appeal, separately. But ultimately, the respondent's complaint is that the judge should have held the stylization to be insignificant in the context of the 2018 marks. That is just the respondent's preference, essentially, for the purposes of its appeal, because it wants to invalidate my client's marks so there's no longer a trace of them.
Sorry, Mr. Selmy, can I just take you back one step to the bit, the submission that you said was very wrong, was that, which I think, I don't want to paraphrase you, but was the legal tests for the two legal tests, for one for the non-use and one for the other. What would be the legislative purpose of having a different test in that context? Because it strikes me as being a surprising thing to have a different test.
So what I can say is the statutory basis is obviously different, and the way that the case law has evolved relating to Section 3 is entirely different from Section 46. Ms. Lane took you to a passage, I think it's paragraph 150 of the judgment, which is talking about permissible variant use, and it makes the point that it covers use of a mark in form in which it was registered. Only if there are insignificant differences between the two signs, then you can regard them as being broadly equivalent. But there's no basis to say that that test is what the court should apply when considering stylization. That point was not addressed by Mr. Justice Arnold in Starbucks. It wasn't addressed by Mr. Hobbs in Flying Scotsman. So far as I'm aware, Section 3 and Section 46 have been kept entirely separate in the authorities. So I would take issue with the submission that
Okay.
because this uses the language in significant respects, we can take that to mean the same as effectively nominally stylized or figurative fig leaf. So it is my submission that the respondent has not identified any error, flaw, principle that would allow this court to airbrush those elements out of the 2018 marks. And for those reasons, the first and second grounds for appeal should be dismissed. And that also disposes of Google's third ground for appeal, which relates to section 3.1d and whether the 2018 marks consist exclusively of signs or indications which have become customary in the current language or in the bona fide and established practice of the trade. And that statute also uses the language exclusively, and the respondent contends that exactly the same errors apply as for descriptiveness, so I don't need to address it separately. Next is the respondent's fourth ground of appeal, relating to the distinctiveness of the 2018 marks. If I could ask the court to pick up the judgment at paragraph 119 and page 32. So this is section 3.1b provides that trademarks shall not be registered if they're devoid of any distinctive character. The judge summarised the law at paragraphs 120 to 122. The important points are, as the judge set out at paragraph 120, that section 3.1b is broader in scope than section 3.1c or d. So that's to say that just because a mark is not descriptive does not make it distinctive. And as the judge says at paragraph 120.3, for a trademark to possess distinctiveness, it must serve to identify the product in respect of which registration is applied for as originating from a particular undertaking. Then at paragraph 123, there's the assessment. So far as the 2018 marks are concerned, I see no independent basis for considering the 2018 marks to be objectionable under section 3.1b. However, in my view, the distinctive character of those marks is low and arises from the particular combination of the word shorts and the place symbol rendered in red in the O. Now, the respondent contends that the judge's analysis on distinctiveness is wrong for two reasons. First, for the same reasons already explained in relation to grounds 1 and 2, so the same submissions apply in response to that point here as well. Second, the respondent contends that the judge didn't undertake an independent analysis under section 3.1b. And it is of course right that as a matter of law, a mark may lack distinctiveness for reasons other than being descriptive, but the judge firmly had those points in mind. As I mentioned at paragraph 120, he specifically noted that, as is apparent from Technopol, section 3.1b is broader in scope, so that's a point of principle. He then went on to cite specific legal points relating to distinctiveness under its own heading before undertaking the assessment, and specifically noting that the distinctive character of the 2018 marks is low and arises from the particular combination of the word shorts and the place symbol rendered in red in the O. So that clearly shows the judge undertaking his own assessment of distinctiveness on these facts, and doing so with the specific public interest that underpins section 3.1b firmly in mind, which is that only distinctive marks should be registered. The respondent also fixed on Mr. Justice Arnold's discussion of the interplay between descriptiveness and distinctiveness in Starbucks. I don't need to take the court back to that judgment, but you will recall that Mr. Justice Arnold, as he then was, makes the point that nominally stylized marks may be invalidated in one of two ways, either by treating the stylization as insignificant in the context of the mark as a whole and finding them to be descriptive, or to say that they're not descriptive but are not capable of being distinctive. Now, it's pointless looking at specific examples where that was held to be the case, since every case turns on its own facts, but it would be entirely wrong to say that if a mark has some stylization and it's held not to be descriptive, then it must lack distinctiveness, because that would be entirely circular. But of course, there's some circularity to the respondent's analysis, which is that if the stylization is a figurative fig leaf, it's descriptive, but in case you don't find that, then we're dealing with a mark that's plainly not distinctive. But in circumstances where we say the judge was perfectly well entitled and correct as well to conclude that the stylisation was not inconsequential, and as an entirely separate matter, that the 2018 marks were distinctive, there's no basis to interfere with the distinctiveness finding either. Before addressing the respondent's sixth ground of appeal on non-use, if I could very briefly address the court on the appellant's respondent's notice.
Just before you do, Mr. Stanley, one question I meant to ask earlier, forgive me. If I've got, my memory is that Starbucks, there was a mention of this earlier, it went on appeal, but I don't think that bit of Starbucks went to the Court of Appeal. Is that right?
I think that's correct.
So what's the status of that passage in Starbucks? Is it still something which is only a first instance decision, or has it been subsequently approved in some other Court of Appeal? Or is this a whizzing opportunity for this Court of Appeal to agree with it?
I don't think that point was discussed on appeal, but I don't think there was any objection.
In Starbucks, I don't think it was either. I just wondered whether it had been picked up in any other appeals subsequently. So what's the status of it?
I'm afraid I can't answer that. I'm not aware of that point having been picked up in other appeals. And I think in this case, both parties relied on the same figurative fig leaf language from the same authority. In relation to the respondent's notice, if I can briefly take the court to that. So this is in the Corn Bundle, tab 9, page 273. There are two respondents' notice points, but they break down to three grounds. So the first sentence is, the judge rightly found the 2018 marks to be validly registered because of the effect of the combination of the word shorts and the place symbol. So that's making the point that he was right about the stylisation. Then there are the three respondents' notice points. So the first is that even without stylisation, he should have held the 2018 marks to be inherently distinctive based on the word elements alone. Mr. Malinich had addressed the court on the inherent distinctive character of the three mark for Shorts TV, and the same arguments apply here, so I won't make any further submissions. The second point...
Just hang on, since you just drawn that to my attention, this is, the respondent's notice isn't specific to the Sports TV 2018 marks. It also covers the Sports 2008, Shorts, I'm so sorry, Shorts. Shorts, it does, what you just submitted there makes sense relating to the 2018 Shorts TV marks, but it doesn't make sense in relation to the 2018 Shorts marks.
If I can just clarify that, because in the judgment, the judge addresses the Shorts TV marks first, and then later on he says that exactly the same points, when considering descriptiveness, apply as for the other marks.
I can understand, I get that, but just to put flesh on the point, what Mr. Malinich was talking about was the distinctiveness of Shorts TV, putting together the TV and the Shorts, which I understand, and that's a point, and I can quite see, as you put it, Mr. Selmy, that that point could be applied to the word element of the 2018 Shorts TV mark, but it doesn't apply to the word element of the 2018 Shorts mark, and I just want to understand whether you're saying it does, or what are you saying?
No, I think we're just relying on the Shorts TV marks. The second respondent's notice point relates to acquired distinctiveness. So if we fail on inherent, we say that we have acquired distinctiveness. Again, Mr. Malinich should address that, so I don't intend to say anything further. And the third respondent's notice point relates to the proposed amended specifications in respect of some of the goods and services with the rider save for or in relation to short films. And the judge held that that limitation lacked clarity or coherence. But here again, Mr. Malinich has made the relevant submissions in response, so I don't have anything further to add on that particular point. And finally, ground 6, which is the revocation of the 2018 marks. If I could ask the court to return to the judgment, which is Core Bundle tab 1, page 40. So the judge comprehensively set out the law on genuine use at paragraphs 145 to 152. So this is under the heading revocation for non-use. There's no dispute as to the correctness of what is set out there, but I do need to draw the court's attention to paragraph 149, where the judge considers the law on section 46.2, which relates to variant use when the use of a mark in one form validates the use of the mark in another form as registered. And the points of principle for the purposes of my reply are point one, the objective of section 46.2 is to allow the proprietor of the mark in the commercial exploitation of the sign to make variations in the sign which, without altering its distinctive character, enable it to be better adapted to the marketing and promotion requirements of the goods or services. Then the second point, there are two parts to the necessary inquiry. First, to identify the points of difference between the mark as used and the mark as registered, and second, to ask whether those differences alter the distinctive character. And then the third and final point of principle, the normal approach to the assessment and comparison of distinctive character applies in this context. Accordingly, it's necessary to analyse the visual, oral and conceptual qualities of the mark as used and of the mark as registered, and to make a global appreciation of their likely impacts on the average consumer. The only legal point that arises in respect of the respondent's sixth ground of appeal is whether, on the facts of this case, Shorts TV Plus, so Shorts TV with a plus at the end, counts as use of Shorts TV. And the judge addressed this at paragraph 154 on page 43, which I took the court to earlier. Partway down the paragraph, while I agree that the plus adds a visual element and an additional syllable orally and has some conceptual significance in suggesting something more, I do not agree that it adds anything significantly distinctive. Insofar as those marks have distinctive character, that distinctive character is retained rather than altered. The respondent makes three complaints to the judge's finding here. The first is that the judge treated the plus symbol when assessing variant use differently from the way that he treated the stylized elements when considering the validity of the marks. I've already explained why, in my submission, the factual and legal issues are completely different, and there's nothing at all inconsistent about the judge finding the 2018 marks to be valid on account of the stylization, but holding that the plus element does not change the distinctiveness of Shorts TV here. The second...
Sorry, Mr. Matt, forgive me. The mark that the judge is actually considering, if I've understood the beginning of 154 correctly, although it's handy to label it Shorts TV Plus, it's actually not just Shorts TV Plus, is it? It's got the play symbol.
That's exactly
That's
right.
what the judge means when he says in the form of the 615 marks, but with an additional plus.
I think that's exactly right, my lord. I think it is the 615, 649 marks, but with a plus as well.
So the thing that's not altered the distinctive character of is a mark. What you're envisaging is the Shorts TV with the play symbol and a plus.
And a plus.
Yeah. Thank you.
So we say there's no inconsistency between those two findings. The second point is that the respondent contends that the judge failed to consider the, I'm quoting the skeleton, very low distinctive character of the stylized Shorts TV marks. And that's wrong because the judge expressly held the 2018 marks to be distinctive at paragraph 123 of the judgment, which I took the court to earlier, noting that the distinctive character of those marks is low, not very low, as the respondent wrongly suggests the judge held. But just because marks have low distinctive character does not mean that the addition of a plus element, being a point of difference, necessarily alters that distinctive character. And that's not the law on permissible variant use. And the third point is that Google contends that the judge asked himself the wrong question at paragraph 154 by considering whether the plus element adds anything significantly distinctive. The judge did use the language significantly distinctive, but in doing so he was obviously not changing the statutory or legal tests. He was simply making the point that the plus element was not that distinctive, his relevant conclusion being that the distinctive character in the 615, 649 marks, which are the stylized Shorts TV marks, was not altered by the addition of that element. So here again we say there's no error of law or principle, and for those reasons that ground 6 should also be dismissed. My lords, my lady, unless there are any further questions, I don't have anything further.
Mr. Zelmi. Mr. March.
My lords, my lady, propose to address three topics. The Section 10.2 infringement appeal and two sort of subtopics within that. Section 10.3 appeal in relation to the finding on the appropriate market for the purposes of assessing reputation, and the Shorts TV word-only mark, which also carries with it the Shorts TV use within the composite marks. So the first point that I need to come back to relates to the court's concern over the appeal based upon lack of a single, or the finding of a single meaning rule. It's very clear on the authorities that it's inappropriate in a trademarks case to adopt a single meaning rule in most cases, and that's because consumers are a differentiated bunch with different perceptions and different understandings. And that's clear law, Court of Appeal in the case law that I showed you in opening. Now, it was said against us, and the court clearly had some concerns too, that we were criticising the judge about this, but he reached no finding that there was a segmented public, or any particular finding that there was a portion of the public that only understood shorts as indicating short films. Now, the first point we make about that is the essence of the criticism that we are making. He adopted a single meaning monolithic rule. He adopted a view of consumers that they would all understand that it means any kind of audiovisual entertainment, that is short. Now, so the starting point is it doesn't meet the criticism that there was a wrongful adoption of a single meaning rule to say, well, he didn't find a differentiated public. That's correct. He didn't in terms, and that was an error. But there are also indications in his judgment of an implicit acknowledgement that there was and must have been a public who understood different meanings. And what I mean by that is in paragraph 258, the centre of gravity paragraph, where the judge was acknowledging that the meaning had shifted as a result of Google's acts. To some extent that's irrelevant because we've got to look at the position before the acts complained of commenced. But let's just stay with that. The fact that the judge was acknowledging a shift in the centre of gravity means that there must have been a segment of the public for whom shorts meant, prior to the move in centre of gravity, only short films, and that Google's activities had shifted the centre of gravity away from short films. So it stands to reason that there was a shift in the meaning, and given that you're dealing with a public who are going to be perceiving this sign at different times, you're going to have a different perception. Now, that's the first point. The court doesn't need an express finding of segmentation, especially since we criticise the judge for not doing so. What we say is that it stands to reason that there were a public that perceived the mark in different ways. Now, there are many other reasons why Google's use could not possibly be regarded as being descriptive. It has always been a point of such artificiality to suggest that somehow, in relation to user-generated content shot on a mobile phone in vertical mode, showing pranks and hijinks and maybe a dance step or whatever, that the word shorts was descriptive of that. This is social media that is there to be engaged with, to be enjoyed for less than a minute before you scroll to the next video. And there is no question, in my submission, but that the word shorts, when used in relation to that, for people familiar with the meaning of the word shorts, must consider that to be elusive.
I'm sorry, I actually don't understand what you mean, Mr. Malkovich. Don't just repeat yourself if you don't mind.
No, of
Explain
course
what you're. I don't understand what you're trying to say.
What I'm trying to say is that a user confronted with the Google service for the first time and scrolling through it and seeing the word shorts. Now, there are other reasons as well, most importantly, the branded use, but purely in terms of what that product is. And in light of the fact that they know that the word shorts means short films, we say that there's going to be a significant proportion of people who know that term.
So what you're positing is someone who, you say know it means, you're talking about somebody for whom the word shorts,
Yes.
in a context of media,
Yes.
let's say, means and means only short films.
Means only short films, but even if
I don't mind all your even ifs. I just don't understand what you want to say.
That's the starting point. That's the starting point.
So I've got in my mind someone who's got their phone. I don't really understand why social media is relevant, but you place that's one of my. You say it's obvious because it's something to do with social media. I just don't understand why that follows. But they're on their phone. They see the word shorts.
Yes.
They are someone for whom that word only means in this context short films, which is not, the judge, I don't believe, held that such a person existed in his main findings. You say you can infer from later on that there was such a person, but never mind, but that's all right. So you say that he should have held there was such a person who has this view. They think they believe it means short films.
Yes.
They see it on their phone. Okay, now you go. I'll stop.
They see it on their phone, and they see this clip of somebody dancing or pranks or whatever, lasting less than a TikTok, in vertical. It's a home video.
Okay.
It's user generated, and they think that's a clever name for the service. They don't think.
They think it's a clever name for the service.
Yeah.
Okay.
They think it's a badge of origin.
Why?
For the platform, because it doesn't perform a descriptive function in relation to that content.
Can I say to you, I'm standing there, I'm looking at the phone, I see a short video, I see the word shorts, I've seen a short video. I'm really not understanding why it is so intuitively obvious, as you're putting to us, that it is as night follows day, that they think that the word shorts was being used as some kind of trade origin. That's the thing I don't understand.
Right. You must be. Well, there's a number of additional reasons. First of all, and they're all related. The first of them is that you must be within, to put it in traditional terms, within my goodwill.
Okay, so you're someone
because you're the
whom,
average consumer
okay,
of my trademark. So, and you've got to be someone to whom the mark is particularly distinctive, or it has whatever distinctiveness it has. All right. Now let's say it's descriptive.
So I'm starting from the point that shorts really does mean to me short films and nothing else in this context.
Yes, I mean but that's where the even if comes in. Even if you took the view, as the judge did, that it had become used in relation to comedy shorts or some smaller clips on television and so on, and there were a few isolated instances more recently, the judge's findings were related exclusively to recent years. Even if you took that view, right, that meaning did not displace the principal meaning, which would be in your mind, which is shorts indicates short films.
Okay.
And short films are a very clear category of goods and services, or production of short films, in the sense they have their own festivals, they have their own awards ceremonies, they have their own audience. I mean, I'll come to reputation in a moment.
So I think where I've got so far is I've got a person for whom the word shorts has this very particular meaning about short films.
Yes.
They now see it being used in relation to, I'm just going to call it a TikTok video because that just makes my life easier. And they and so far see, and this is part of the point you're trying to make, I think, that they're now seeing it being used in relation to something which is not what they would call a short film.
Yeah, something they've never seen it used before.
Okay, never, fine.
Because even the extended uses
So what? Yeah,
relied
I'm
upon
with
by
you. I'm with you. It's not a short film within your
Yes.
definition. It's a
Yes.
TikTok video, and that's not a short film. So
Yes.
what?
So even in relation to the extended meaning, right? Even if people think, okay, I've seen it used away from sort of film festivals about short films. I just have used it in relation to shorter film content. What they've never seen is this audiovisual
It's being a
package.
TikTok video type
Yes,
thing.
yes,
Okay,
the
so,
TikTok
so
videos.
I'm with you. I'm now seeing.
Yeah.
I've seen the word shorts, and I'm looking at the TikTok type short user-generated content video,
Yeah.
and I'm thinking to myself, oh, I've never seen the word shorts used for that.
Yes.
So
And so what you've got is, first of all, that makes it not descriptive in the sense understood by the authorities, Technopol and so on. But just hear me out. Even if it is descriptive, it's descriptive in a different way.
Okay.
So you could say, and that's why if it were a validity issue, if someone just applied for the plain word shorts, you could say, well, one of its possible meanings is short clips and therefore it should be denied registration. That's a different approach when it comes. We're dealing with infringement here.
Well, at the moment,
And
I'm
the
not dealing with
judge-
anything actually. Just to be absolutely clear, what I'm dealing with is not some legal category for any of this. I'm just trying to understand what you say the thought processes are of someone, because that was the submission
That's-
you were making.
Yes, yes.
And I know as lawyers, we're all sitting here godlike looking down on it, wondering about whether it's infringement or validity. And that's not what we're talking about. I'm talking about a person.
Real world,
Yes.
the person has to think the word shorts is irrelevant because it's descriptive of that content. That's what the judge did, right? So he basically said, I'm going to remove from the analysis the word shorts because it's purely descriptive. It doesn't count in the analysis. And the only reason for doing that would be if it were descriptive, we say, which it's not, and even if it were descriptive in the same way.
Can I just say, Mr. Malish, you're straying away from the bit I'm trying to understand, because you said it to us on the first day, and you repeated it, and what the reason I intervened is that you stand and say to us that it's, in your mind, if I may say so, it obviously seems so clear to you, you can't understand why this bench is not getting
Persuade
it.
myself first, right?
Of course. And you're saying that the person within your goodwill, which is a nice way of thinking about it, in the sense of they're the people for whom shorts means short films.
Yeah.
They see this user-generated content on a phone, and they've seen the word shorts in relation to it, and you keep saying that at that point it's a trademark, that it's trademark use, and that's the bit you still haven't explained to me.
Yeah. Well, first of all, because it doesn't describe a short film. What they're looking at is not what they know as a short film. Reason one. Reason two, the use made is distinctive use.
Is it?
It's got a logo above it. It's the only logo in question. If you take the blow-up handout that I gave you on the first day,
It's
please.
the icon.
I only really need to succeed on one of these, and it's very, very simple. It's this page here, so it's the page, still that page.
You really should have put numbers on this, Mr. Malish, shouldn't you? Never mind.
Page 6.
Page 6.
Page 6. Page 6. Mobile screen.
Yeah.
The judge accepted that this was trademark use. He accepted that there was no YouTube
This you're referring to is the top
on the one on the right.
right-hand side picture, top.
Yes,
top
recreating an Oysters Rockefeller recipe from taste, reverse engineer. That one.
Yeah.
That was of critical importance.
The red blob on the left of shorts.
Red blob Turkish delight. Yeah, red blob shorts, and then below that at the bottom shorts. Those two uses, right? So in relation to this, the judge accepted that it was a reasonable and realistic scenario, post-sale confusion and so on, for this to be shown. Someone shows their screen to a colleague, a friend, and that's all they see. So there's no YouTube or anything. Actually, I would add to that although it's not shown on this screen, there is also the bug that could have been there on some of the videos. You remember the bug on the first day, the graph. So the only possible trademark aspect of this is shorts.
Right.
Right. So that makes it as well rather unlikely that it's going to be taken to be purely a descriptor of the content. And the judge, quite rightly we say, left out of account other signs like YouTube, things like other things that were on the menu and so on. So we've got someone confronting that. They know short films. They see what this is. This is not short films. These are clips, home-produced videos that they can scroll, they can engage with and like, comment on, and so on. So that's it. As simple as that. If it is descriptive, we say it's elusive. But if it's descriptive, it doesn't really matter.
Just elusive. It's a word elusive you've used many times.
Yes.
What is what elusive of what?
Elusive is a suggestion of a characteristic without directly.
I understand what elusive.
Yeah.
Forgive me.
I mean, sorry, I'm using it in a slightly technical
I don't understand
sense.
what you are using it to refer to. Something has to be elusive. There's an A. A is elusive of B. What's elusive of what in this?
Right. So it is elusive, first of all, to anybody who knows about short films. It's elusive to short films
Right.
because
Doesn't it just mean short films on your case?
no, because it's not a short film. It doesn't. It's got to be assessed in relation to the goods. It's as if you had. It's a better example is actually Instagram Reels.
Isn't it wrong rather than elusive on your case? If you're reading this and you think shorts means short films, it's not elusive.
It's deceptive.
Maybe it's wrong. I mean,
No.
maybe it's deceptive. But
No, it's not. It's not deceptive. What it is it's suggestive. It's a trademark. It's a perfectly good trademark in a sense because it is memorable, distinctive, and so on. That's the issue. So that makes it wrong for the judge to say, I'm going to essentially excise the word shorts from the analysis, which is what he did. And I'll take you that in a second. So I don't think I can say more than that. We say the manner of use, the mindset of the consumer, the nature of the audiovisual material, all make it not descriptive, directly descriptive, and therefore make it illegitimate for the judge to simply say, well, we'll just ignore that word, just focus on the stylization.
Okay.
Unlike Nicker Ventures, which was directly descriptive, symmetrically descriptive of both claimant and defendants' products and services. So that's the first point. The second point is
just forgive me, just before we get to your second.
yes.
Single meaning rule. What do you say the single meaning that the judge used was?
The single meaning that the judge adopted was that all consumers would consider shorts to indicate short form video content, all of them. And we say that's wrong because
I
that,
thought he didn't say that.
well, sorry, the definitional, I'm misquoting it slightly, but I mean that's,
Okay, well, you say he wrongly applied a single meaning rule,
Yes.
which I think you mean, as I understand it, that he decided that it had a single meaning.
yes.
And I want to know what single meaning you say he chose.
I will quote it. So it is 58. I conclude that as of 20th of February 2018, the meaning of shorts was not limited to short films, but also included other short form
That's the single
audiovisual.
meaning.
That's the single meaning.
Thank you.
Right. So we say that is wrong.
That's fine.
Yeah, that's it. Then we come to the issue of double counting and polluting the comparison. Now, my learned friend took you through the Flexi Air case. I'm not sure why, because that case is dead against her. And there was reference made to the compressor case. Again, dead against her. There is nothing for Google in any of those cases, my lords and ladies. Those cases make two propositions very clear. One, it is illegitimate as part of the pure comparison exercise to bring in distinctiveness. It's just a separate thing. It's like defining average consumer by reference to distinctiveness or similarity of goods by reference to distinctiveness. It's just not relevant. That is clear from the Flexi Air case. The second problem, so the judge, I mean, the paragraph of the judgment could not be clearer. There is a heading, I took you to it, an opening, and he immediately finds that there is, he can leave out of account, it's the, sorry? Yeah, page 65, and it's headed comparison of the signs, sign and mark, and he immediately, as part of that paragraph, brings in distinctiveness. My learned friend said, well, what about his conclusory paragraph? He puts all the wrongs to right in the conclusory paragraph. Well, we say the conclusory paragraph actually engages in triple counting. All it does is repeat what he said about the comparison of the marks. You can see that from paragraph 240. So in 240, he's dealing with the handout that I just gave you, the mobile screen, which he's blown up to a very, very unrealistic extent in the graphic above. But leaving that aside for the moment, I'll come back to that. He says, I bear in mind they both contain shorts, which gives rise to visual, oral, and conceptual similarities, and that the sign is used in relation to identical goods. And then he goes on to say, however, the word shorts is descriptive of the material in question, and the play symbol indicates that the material can be played. So that's exactly what he said in the comparison paragraph. And for good measure, there's also, he goes on to say, a few lines down, the marks are registered for and the sign is being used in relation to goods or services for which the word shorts and the play symbol indicate characteristics. So what we have here is at no point in the judgment do you have an independent assessment of the weight to be given to visual, oral, and conceptual similarity. I think you asked me in opening, my lord, whether he'd reached a finding of high, medium, and low. I'm not sure that's necessarily required, but in a case like this, you would expect that point to be given some weight. I mean, it is in the light of the compressor case, which says that in principle, you can have a likelihood of confusion, even with marks of low distinctive character. It just has to be, the exercise has to be gone through. And what we have is a highly artificial exercise of dissecting the mark and reducing, reductio ad absurdum, reducing the mark to the placement of the play symbol, which in my submission is just simply not something that the average consumer would participate in. I mean, if you turn back to the graphic, my learned friend described it as a terrible argument that the O in the word shorts does or does not contain the play symbol, because I'd submitted that it was rationally insupportable to say that consumers would know, notice, visualize, perceive, whatever word you want, whether the little word shorts at the bottom of the screen contains a play symbol or not. Well, I'm not sure if it's the copy that I've got, but I certainly couldn't tell you now whether that shorts contains a play symbol or not. But actually the point is a slightly different one, which is they wouldn't look for it. They wouldn't notice it even if they did, even if they were able to perceive it, because it is such a minor detail. What you have is a clear word shorts, which assuming some distinctive character for my valid marks, which for the purposes of infringement they're assumed valid, and you've got, for good measure, a play symbol above that. Whether you think of that as a logo or an icon matters not. And so we entered the realms, we say, of the fanciful, where the thing that was quite clear front and center, that was similar about the marks, was ignored, airbrushed out, for reasons which we say were wrong in principle.
Sorry, what was airbrushed out?
The word shorts. Right. Airbrushed out at every stage because it was regarded as being descriptive, which we challenged that as a proposition. But even if it were accepted, it still has to be factored in as a point of similarity, and it could still cause a likelihood of confusion. It is really quite artificial and wrong for the judge to have reached this view.
Forgive me, does your conclusion of your argument that you can't really see where the play symbol is and so on is that any use of the word shorts infringes?
Not necessarily, because it is possible for, well, if there were to be, let's say, a short film service, another short film channel, who is using it descriptively, right, in the classic way that we are using it, then the descriptive meaning would be there. And then the question would be, how are they branding it? Has it been stylized in the same way? If it's in green or whatever, it might be different. It isn't a monopolization of the word, because we wouldn't have valid marks if that were the case. Obviously, we've got...
Yes, but in a sense you are looking for a monopolisation, at least outside your concept of short films. Is that fair?
We are looking for, I suppose we are looking, it is a trademark monopoly, so of course it has its effects. It has a modest level of distinctiveness. We acknowledge that. It's got some, but it's got a modest level of distinctiveness.
But at the moment, because you're discounting or trying to say it's too small to worry about the play symbol,
yeah.
The focus must be just on the word.
Well, actually, there is a place symbol as well, of course. It's just in a logo above, as opposed to within the O. That's why I say it's not just the place symbol. My learned friend, Mr. Selmy, made this clear. It's the placement of the place symbol. They can't rely on colour to militate against confusion. The colours are the same too. So we end up with the placement of the place symbol within the O. And as I showed you, if you look on the previous page, the various brands that Google have used, the place symbol gets sometimes put on the side, above, in another word, configured in a different way, and so on. So it isn't as if there's a sort of distinctive way that it's used. And we say this is a case where likelihood of confusion ought to have been found because, sorry, one second. Yes. Yeah, so it does amount to simply placement of the place symbol. And this was a case in which the obvious conclusion was to say, most people think this means shorts. It's not descriptive as used by Google. They're straining every nerve to turn it into a trademark. I mean, it is really quite astonishing to hear this submission made 4 or 5 years after launch, when nobody else uses the word shorts to refer to these clips online. This is a Google trademark. TikToks aren't calling themselves shorts, and nor is anybody else. This is a Google platform for its very short videos. And in fact, on that point, addressed Milady's exchange yesterday with my learned friend about professionally produced content sometimes being on YouTube. Yes, that is so in relation to ordinary YouTube. It's obviously a major outlet for film content. That's YouTube, but that's not Shorts. Shorts is a very different animal. This is principally user-generated content, all shot in vertical format mode, mostly mindless stuff, which is engaging and fun, which can be scrolled through, and indeed often is scrolled through up to an hour at a time. So you're watching 50 or 60 of these videos at a time. I'm just looking at the picture on the screen. Yes.
That you showed us. If those videos, I mean, I get that weirdest waves ever.
Yeah.
Feels like more of a TikTok video than a rather sophisticated 15-minute short film with actors and everything else.
Yes.
I can't help thinking that if those 4 things were in fact short films within your class definition, you would still be standing exactly where you are in exactly the same case, fighting just as hard.
Well, I think we would, and the reason for that is because they are using it as a trademark. There's no question about that, my lord. This is the court's result here allows Google to run off with our trademark and use it as a trademark. There's no doubt about that.
Part of the point of my question is I'm not sure whether the fact that these things are not short films, as you say, is as significant as you appear to be saying it is. That's the bit I'm not understanding.
There's no doubt that content can vary, and there might be some some different kind of content that might be taken as being a short film, a very, very short film. But that's at the margins, my lord. And one also has to take the date of assessment when they first started. So, you know, this was the service to take on TikTok, because TikTok had started to march on everybody. TikTok had been banned in India, and so there was an opportunity for Google to get in there with YouTube Shorts, and that's what they did. The competitor products are Instagram Reels and TikToks, and those are called those names, just as this is called Shorts. So, my lord, lady, let me turn on to, there's just one other point I wanted to just respond to my learned friend's legal argument. You'll recall that she took you to the standard summary of principles, and one of them, when it comes to the comparison of the marks, is that you should take account of the dominant and distinctive aspects. And that was said to be a kind of way to smuggle in an assessment of distinctiveness on comparison. That would be a very surprising result, because there's so much case law that says comparison is something to be carried out on its own without an assessment of distinctiveness. I mean, we didn't look at half the authorities. There's China Construction Bank and some other cases as well. And the reason for that is that when the court says dominant and distinctive aspects at the comparison stage, they're using the word distinctive in a non-legal sense to mean differentiated, prominent, whatever. The key is to interpret dominant and distinctive together. This is not an assessment of descriptiveness or the trademark badge of origin value to be ascribed to terms. That comes in later. It is very, very clear in the court's case law.
So, are you saying that under the global assessment of likelihood of confusion under 10.2, distinctiveness or its counterbalance, descriptiveness, doesn't come in?
No, of course. No, I'm not saying that. No. Absolutely comes in, and it can be the absolute trump card right in the end. I mean, and often is. I'm not saying it shouldn't be. Problem is, it's one of approach. And if you take the wrong approach, you lead to highly artificial exercises like the one that the judge carried out here. No, of course, it comes in very much so. Let me address you briefly on section 10.3 and the short study law. On the section 10.3 case, the reputation and the assessment of reputation, we say you don't need to worry too much about the judge's assessment of the evidence, because he adopted a completely flawed starting point. The starting point was to say that the reputation was the general public at large, and the relevant market was the film market. That was wrong in principle. And the reason for that is, first of all, that the authorities make it clear that you can have a subcategory or a sub-market, so to speak. I mean, otherwise specialized goods would not be able to benefit from a reputation. I mean, it just stands to reason. But, and if any authority for that proposition be required, it's Mr. Justice Arnold, as he then was in the Skykick case, who specifically talks about specialized goods. And then you've also got Falk or J in the Eagle Rare case. So why didn't the judge just say short film? Well, it's quite curious, actually, because this point about the coherence of the category term seems to have been imported from a completely different part of the case and grafted on to the assessment of reputation, where it has simply no logic or sense being. Why do I say that? First of all, because in the post-Cantor case, which I know my learned friend helpfully took you through this morning, that case is not concerned with assessing reputation or the market or any of that. This is concerned with transparency and accuracy of the register, so that people are not allowed to have trademarks for things which denote a negative characteristic. And if you think about that, it makes a lot of sense. You can't have clothing except for green dresses with a red feather sticking out. You can't have that, because if someone's consulting the register, they look at the register, they go, what kind of clothing can I sell so that I can avoid infringement? That's what that's about. And that's the only reason why post-Cantor exists. They even say that in the passage that she read out. It's third parties will not know where they stand if you allow negative characteristics and uncertain registrations to be on the register. And that's also clear for the IP translator case and many other cases. Reputation and the assessment of reputation is a completely different thing. It isn't a definitional thing. It's simply an assessment of whether that party has done enough to have a reputation in the market in which it trades. Now, the market in which it trades, in this particular case, is the short film market. My client does not make feature films, does not trade in the feature film market, save for the fact that the Oscars and Cannes and so on also have short film or court-metraged competitions as well, which my client attends. But apart from that, there is no specific activity in the film market. Therefore, it's wholly unfair to judge it by that standard. It would mean that the leading player in the short film industry, in fact, I would suggest that's us. If it isn't us, it's maybe us and one other, is unable to benefit from a reputation, even though in that industry it is a well-known player with well-known trademarks. So once you comprehend that the judge's approach of defining the market as being the entire film market, one can well see why the evidence didn't come up to scratch, because 14,000 viewers, leaving aside any date points and so on, it just doesn't sound like very much. And 900 tickets to watch the Oscar shorts, again, it's not very much when you consider the general film market. And so, of course, the judge took a very, very parsimonious view of the evidence, which, to be fair, had its limitations as well. But we say that that approach was so flawed that that part of the judgment can't stand. And once that's accepted, then it's just a simple matter of looking through the agreed use document. And we had, we're responsible for the most well-known event in the world of shorts, which is the Oscar shorts exploitation, and have been for years. We've had pretty much an unbroken channel on the UK in some form or other exhibiting only short films. No one else has such a channel. And we have been selling them, we've been producing them. The evidence was that we get many, many calls from directors and so on who want to deal with us. And there was witness evidence that was either unchallenged or unchallengeable about our reputation in the market. Now, it was said this morning, oh, that's Shorts International, or not your trademarks. But when your trademarks are shorts, and you are known as Shorts, or Shorts International, we're not known as SIL. In fact, my client has always taken great exception to that court abbreviation in the judgment and so on, because we're known as Shorts. That's what we're known as. So when you have a reputation of shorts, it's sort of quite, it's an easy thing to say that you've got a reputation, or your marks of a reputation, if indeed you're providing the activities that fall into your trademark, which you are. And so that really is the only point on section 10.3. I think I've already addressed you on the centre of gravity. We say that is, you put to my learned friend this morning, the point that I would say, which is that if they are forcing us to take action, to explain ourselves, then that is an effect on the consumer behaviour. And my learned friend said, well, all we're doing is changing the meaning of shorts to another type of meaning. Not quite. They are changing the meaning of shorts to indicate a different type of content from a different party. And that party is one of the biggest, most pervasive commercially undertakings in the world. And therefore, they're going to have an effect on consumer behaviour. They are swamping the business, and it is hardly a stretch to consider that they are having an effect on the distinctive character of the marks. The judge didn't think so because he thought that our play symbol placement was not affected, but that's because he approached the entire mark on a very narrow basis, which we say was wrong. On the 353 mark, the Shorts TV mark, I just wanted to respond to a couple of points my learned friend said. So she came up with the example of the DVD in a shop, which she said, if you see shorts on that, you might think that's got short films in it. We agree. We're dealing with shorts TV here. It's very important that the entire mark must be assessed for its suitability as a descriptive term. Nothing in anything she said would lead anyone to believe that shorts TV is suitable as a descriptive term for any of the goods and services. It just was never, it wouldn't fit as an adjective. It wouldn't be, we're not going to watch shorts TV tonight unless you mean a particular channel. It's not a type of television. It's not a type of good. It's not a type of service. So it comes down to a sort of general, well, it's comprised of different non-distinctive aspects, and it's not put together in a very clever way. But the problem with that is if you take the mark as a whole, it just isn't suitable as a descriptor. If I see a DVD in W.H. Smith with shorts TV on it, I'm going to think, oh, what is this, a compilation of videos from a channel called Shorts TV? Obviously. That's what I'm going to think, and that's the problem. When it comes to computer software, the submissions were extremely strained because the number of mental leaps that have to be gone through to actually think, the consumer has to think, well, that must be as a means of accessing entertainment generally. Shorts TV is a type of entertainment rather than, oh, that's the app from Shorts TV, a channel called Shorts TV. So, my lords and lady, that I think would conclude my reply submission unless you have any further points.
One question.
Yes.
It relates to something, the thing we were discussing earlier when I was asking you about the I'm not going back over that, but there was just one thing that you said which I'd been mulling over, and I wanted to just make sure I haven't misunderstood. This was about imagining a person for whom the word shorts means short films. And you said, and I understand criticising you for saying it, you characterised that as being, that's the one way of just thinking of that is the people within my goodwill. And
Yes.
I just wanted to pick up on that, because when one says the people within my goodwill, what that means, at least as far as my thinking is that, in other words, that's people for whom shorts means you, your clients. They understand that meaning of shorts.
Yes.
But I don't believe that those two groups are coincident.
No.
The judge didn't find, when the judge found that the word shorts had a predominant meaning of short films,
Yes.
and then the extra twiddle, he wasn't saying that
To people within my goodwill.
that he wasn't talking about the people who regarded that word as meaning your client in any way.
No.
There is a difference between those two.
There is a difference, and there's a passing off finding which goes into
that's
the
a different
specifics of
issue.
people within my goodwill. Right.
But,
So
but,
those
but,
are, yeah.
but in terms of the analysis that we're performing, we
Yes.
absolutely don't need to go back over it or anything. But the analysis that you're talking about isn't talking about positing someone who's looking at this as someone who recognises shorts to mean your client. You're talking about someone who recognises shorts to mean short films, or are you?
Well, what I mean, I do slightly conflate them. I don't conflate them to the extent of passing off. But all I'm contending for here is the definition provided by Lord Justice Arnold, Mr. Justice Arnold in Skykick, where he defines the average consumer in the judgment. It's quoted in the judgment, and he says the average consumer is notionally taken to be someone familiar with the trademark, encountering the defendant's sign in context. And that's a good summary of the position in trademarks. So it's familiar with the trademark means they kind of know me or have had it. Yeah.
So this isn't about how many people there are.
No.
Because when you say the judge wasn't right in the end to say you had no reputation, but at the relevant date, any reputation you had was pretty small. You say it wasn't so small as not to count. I get
Yes,
that. I
it
get
is.
that completely. But
Reputation is not an onerous requirement, again to quote Mr. Justice Arnold. Yeah.
But for the purpose of the infringement test, and that's C, the reference you gave us, you posit someone who is an average consumer who is deemed to be someone who is
Yes.
familiar with your trademark.
Exactly,
It is a
under 10.2.
it is a legal standard and
Correct.
a deemed thing. Yeah. Okay. Thank you.
I just want to give you the paragraph number of that. It's in the, I've turned to it a couple of times, but I've now lost it. 10.2 the law, I believe it's Here we are, yes, 167 of the judgment, he cites that test. Yep.
Thank you.
My lords, my lady, I've got, I think, 6 brief points. My lord, Lord Justice Burrs had a question about the history of section 10.3, and just coming back on that, the position was that originally both the Act and the directive only referred to dissimilar goods and services when they first came in. Then there was some case law in the Court of Justice, which was the Davidoff case and the Adidas case, in which the Court of Justice concluded that the articles as originally formulated must be interpreted as providing for protection for well-known marks in cases where the latter mark or sign was identical or similar with a registered trademark. And in case you're interested in the dates, that was Davidoff, well, it's reported in 2003 in the ETMR. I don't know what the actual date of it is. And then Adidas is reported in 2004 in the ETMR. And then after that, the EU and the UK legislation was amended. And if it's of any assistance, the position is summarised in Curley on the law of trademarks at paragraph 11.103 in relation to relative grounds of refusal for registration. And there's also a reference to it at 16-110 in relation to the categories of infringement. I just wanted to briefly comment on my learned friend Mr. Selmy's submissions on the Flying Scotsman case, which was in the authorities bundle at tab 10, and really only to say that the he didn't take you to this paragraph, but at paragraph 29, Mr. Geoffrey Hobbs, KC, found that that mark was by a slender margin acceptable. So his finding was that mark was only acceptable by a slender margin. That's page 256 of the bundle. And my lords and my lady will recall that that mark has a really large train on it. I mean, we're not talking about a tiny little play sign buried inside an O. I mean, it's a really huge train. And his reasoning is that that particular image, this is paragraph 27, represents the locomotive emblematically, and the image is emblematic to a degree which shows that the sign is used, is not being used simply and solely as an indication of content. It's a fingerprint of the involvement of a particular economic undertaking. And we say, obviously, that's in contrast to the position here, but of course I accept it turns on its own facts. Now, in my submission, my learned friend Mr. Selmy didn't really address head-on my 2 attacks on the judge's paragraph 96 in terms of failing to address the question of figurative fig leaf and failing to look at visual, oral and conceptual similarity. He made a point by reference to the Starbucks case where he said that it was clear on the facts of that case that the applicant had only applied for a stylised mark because that's all they thought they could get effectively. And he said that hadn't happened in this case. Well, it probably won't have escaped the court's notice that, of course, we talk about the 2018 marks. They're all the stylised ones. That's what they went for first. And one can infer that that was probably because they didn't think they'd get a word mark. So they went for that in 2019. I mean, I don't place any great emphasis on that. I'm just pointing out that that is not a point of distinction in my submission with what happened in the Starbucks case. Now, going on to the test under section 46.2, in my submission, it is clear that the test under section 46.2 is the same, or very similar to the test in relation to section 3.1c, and one can see that by comparing the passage at paragraph 150 of the judgment, which I showed my lords and my lady within the quotation at paragraph 27 of that case, towards the bottom, where it says, where the sign used in trade differs from the form in which it was registered only in insignificant respects. And then you can flick back to paragraph 90, where you see the Flying Scotsman test, and that's the section 3.1c test. The figurative content is insignificant in the context of the sign as a whole. So they are very close, if not identical, tests. Now, Starbucks on appeal, let me show my lords and my lady exactly what was said on appeal about the section 3.1c point, because in my submission it does endorse what Mr. Justice Arnold said, and so that's behind tab 13 of the bundle, and we need to look first of all at, this is the judgment of Sir John Mummery, at paragraph 25 on page 341. And what he says there is that the law on trademarks and passing off, as discussed in the authorities, is analysed by Arnold J. in his judgment with characteristic clarity and accuracy. As no criticism is made of it by either side, I'm content to adopt it without modification and do not need to set it out again in this judgment. So that is, in my submission, an endorsement of what Mr. Justice Arnold said about the law. And then if we look at the application of the law to the facts, we can see at paragraph 93 on page 352, it said, at the end of it all, I am in broad agreement with the judge's disposal of this case and with the reasons given by him for dismissing the action and granting the counterclaim. So that, again, I say, is endorsement of the decision that it was merely a figurative fig leaf. And finally, my lady pointed out that in his submission, sorry.
I'm looking at 95.
Right.
The Court of Appeal, as I see it, decided that the mark now, the registered mark, was devoid of distinctive character.
Yes.
That's not 3.1c.
That's three.
That's not exclusively. That's the second.
Yes, devoid of distinctive character is 3.1b. That's correct. But I'm trying to work out what context this. Oh yes, this is he's expressing the decision in his own terms. Yes.
Yes. And the point is that just, I'm not being critical or anything, but what we're being referred to specifically in relation to what the first instance, when Mr. Saul was at first instance, was about 3.1c.
Well, if you recall what he does, sorry.
Exclusivity thing, and this is what I think was in my mind was a bit of recollection, is that the Court of Appeal, there wasn't anything wrong or anything, it's just the nature of the way the case went is that they weren't considering, they didn't actually need to, it wasn't the ratio that what was said about 3.1c. It isn't, we can't just sort of, doesn't mean anything's wrong, but it isn't the same thing as saying that there was an issue about what the judge said about 3.1c. It was to consider the Court of Appeal, and the Court of Appeal said it was right. They said it was common ground at the beginning, so they won't set it out. And then when they actually came to decide the case, they decided it on 3.1b, not 3.1c. Well,
yes, so I suppose it's correct to say that when the judge says at paragraph 93, I'm in broad agreement with the judge's disposal of the case on the claim and the counterclaim, and the reasons given by him, the broad agreement means he was right about section 3.1b. I mean, I think Mr. Justice Arnold specifically said, I'm deciding it on 3.1c, but if I'm wrong about that, then I'm right under 3.1b. And essentially the Court of Appeal it is endorsing 3.1b at paragraph 95. Yes, my lord, that's right. Apologies for that.
That's all right.
I mean that there is some more discussion there about descriptiveness and distinctiveness, but it's all about the facts, really. And the final point is that my lady pointed out to my learned friend, Mr. Malinich, when he was making his submissions in relation to infringement, that he described the play symbol in that context as such a minor detail. And I mean, this in my submission it illustrates the fact that there is this tension between infringement and validity, but my learned friend is busy when arguing on infringement, saying this is such a minor detail, and you know, if there's use of shorts without the play symbol in it, then no one's going to notice that. And this, in my submission, shows the danger of allowing these kinds of marks on the register. I mean, if you allow a mark on the register which has this kind of very insignificant figurative element in it, then when it comes to infringement, the proprietor of the trademark will seek to enforce it against absolutely everything, including descriptive uses of the mark which do not have the same kind of figurative element. And we say that is why, if we're wrong in our opposition to the appeal, then this court should find the marks invalid. Any further? Oh, sorry, I didn't ask if my learned non-junior wanted to say anything more on the facts.
No, I don't.
Very good. Thank you very much.
Can I thank you all for your patience and also for sitting in the Rolls building? We do appreciate that on this side of the court.
Very good. Well, we will reserve our judgments, as I'm sure you're not surprised to hear. They will be handed down in due course. I should say that the work in the Court of Appeal at the moment means that I'm afraid that you're not going to get it anytime soon. I really think the chance of it coming out before Easter chances are essentially nil. I just wouldn't assume you're going to get it on that timescale, I'm afraid. It'll be after Easter. And that doesn't mean the first day after Easter. But it will come to you as soon as, of course, as soon as we can. It will be done in the usual way. There will be an embargo. The embargo is important and serious. I know you will take it seriously. And we can only finish by thanking you for your submissions and for the preparation that went into this case, which I know was considerable. Thank you.
Court rise if able.